Hi, this is Jim Cunningham, and today we're going to talk about the California residential landlords, hidden traps. There are plenty of them. And if you're watching this, you're either a landlord or a tenant, most likely. And there's a lot we're going to cover here. We're going to kind of hit the high points, but this is very important. This is a disclaimer. I'm a lawyer. My lips are moving. Words are coming out of my mouth. I'm not giving you legal advice. Okay. This is information only. Subscribe to our YouTube channel. It's a great way to stay abreast of the changes that are happening in the law. And there are a lot of changes happening. We're in 2021, a lot of changes happening. So it's important to subscribe to our YouTube channel. I'm an attorney. I'm the managing partner of Cunningham Legal. I'm a certified specialist in estate planning, trust, and probate law, 25 years experience. We have offices throughout California, the Bay Area, and Southern California capital region, which is Sacramento. I'm securities and insurance licensed. I'm also a licensed real estate broker. So I don't sell properties, but I am a licensed real estate broker. And I've been doing this long enough, representing enough landlords. My parents are landlords themselves. I helped them replace a roof in high school in one of their rentals in Ventura. So you sort of live in the dream of being the member of a family of landlords. But a couple of interesting facts here. 40 million Californians, 1 in 2 Californians are renters. Another fun fact is 2 out of every 5 Californians were not born in the United States. So we have 20 million renters. We have 16 million people who were not born in the United States. A very mixed bag of people, but this is very important. Rents have steadily increased since the year 2000. And California has responded to this increase in rents and this, frankly, the shrinking middle class, because a lot of people leave California. In fact, 85% of public employees, 85% leave California during retirement. And you heap on the pandemic. So you got all these things happening. California wants to preserve housing for low and moderate income tenants, and they do pass laws to protect those low and moderate income tenants. The most recent act was the Tenant Protection Act, passed in 2019, effective January 1 of 2020. This affects all rentals in California. Okay, this is very important. All rentals in California, and then there are other rentals that have some extra added protections, and we'll go through that. So again, 20 million Californians live in rental housing. But I do want to say this at the beginning. This is not to bash landlords at all. It's not to bash tenants. Private ownership of rental properties benefits society and fills a role that would frankly otherwise have to be filled by the public sector. So if they came down and said, you can't rent property anymore, that'd be terrible, because landlords do provide an important public benefit. Landlords, and if you think about this, if you're a landlord, you know this, you take significant risk when you purchase a property, you maintain it, and you rent these residential properties to individuals and families. So you take a lot of risk as a landlord. So here's what we're not talking about today. We're not talking about bad landlords, and I would call those slum lords. We're also not talking about deadbeat tenants. We're not talking about how to evict a bad tenant, whether it's economic vacancy, which is economic vacancy, otherwise known as not paying your rent, property damage, a nuisance, whatever it is. We are talking about the following 5 topics. So I'm going to presume that the landlord is not a slumlord and that the tenant is paying their rent. They're not a nuisance. They're not damaging the property. These are all adults who are doing what they're supposed to be doing. But we're going to cover 5 really big issues that I see landlords face. And frankly, I see this day to day. Pretty much every time I meet with a client, most of our clients, vast majority, do have rental properties. And so we do face this with clients. The first thing we're going to touch on is lawful rent increases. I think from an estate planning standpoint, from a financial planning standpoint, it is important to pay attention to this. It is important to increase your rents, and we'll talk about why it's important to increase your rents. It's not fair for you. It's not fair for the tenant not to increase the rents. We're going to talk about the importance of avoiding a wrongful eviction. And I will tell you, a wrongful eviction is a very expensive proposition potentially for the landlord. And we're going to have a special guest here who was wrongfully evicted. And I want you, if you're landlords or tenants or whomever you are, I want you to hear this story. Andrew's going to be joining us in a few minutes. I want you to hear this story because he's going to bring up some things that as a landlord, you might not even thought of, okay? Some real world things that are happening. We're going to talk about return on equity. What do I mean by return on equity? Well, if you're a finance person, you know what that is. Basically, you have an investment And what is your return? What is your percentage return on that investment? We're going to cover that. We're going to touch on selling property without paying capital gains tax. I would put a big question mark on that with the Biden administration. We just don't know what's going to happen. And then we're going to wrap it up with leaving California and what that means in terms of, you leaving California or your rentals leaving California. There's some special rules on that. So let's talk about lawful rent increases. So this Tenant Protection Act of 2019, it passed. Now, owners should raise rents to keep up with inflation. You've got maintenance, you've got, you have the erosion of inflation. However, some owners raised rents faster than the voters wanted. So some owners of properties, and we saw this, I happen to live in Sacramento, we saw this, a tremendous increase run up in rents in really the last 5 years or so, but primarily the last 2 years, a real steep increase in rents. And with half of Californians being renters, they're a very powerful political force. And you cannot underestimate when half the population falls in a certain class, they're going to have a political power, okay, because they have a vote. And so what ended up happening was passage of AB, which is Assembly Bill 1482. It's a Tenant Protection Act of 2019. Now, the Tenant Protection Act of 2019, when I first read this, I thought that's a joke. It permits an annual rent increase at the consumer price index plus 5%. I thought, who raises their rents that much? But it does happen. And if you're a landlord, you might find that you do have to raise your rents. And this might be a consequence of not raising your rents lawfully over a period of time. You go, wow, I really have to catch up on these rents. And then you're not able to raise your rent. So so I would say one takeaway here is the importance of moderate annual increases in rent for your tenants, because it helps the tenant plan. If they know every May or June their rent's going to go up, it helps them plan economically for a rent increase, and you keep it modest and you keep it reasonable. So, but TPA, the Tenant Protection Act, there used to be no restriction on many rentals in California. Yes, we will get to the certain local ordinances, but basically you could just set your rent whatever you wanted it to be. Well, now that's over. Okay, so it's capped at the CPA Consumer Price Index plus 5%, and so the minimum you can raise your rents, the minimum allowable, or sort of the threshold is 5%. So yes, you can raise your rents 5%. Again, this is not if you're in rent control. These are for properties that fall under the Tenant Protection Act, and I'll unpack that in a little bit. But there are some local exemptions to the TPA. Pre-existing local ordinances. That is city rent control. So you'd see that in many cities that we'll cover. Single family residence, condo, owner occupied duplex. There's some exceptions here that are not covered by the Tenant Protection Act. So very important to know that there's some exemptions. If you're exempt from the Tenant Protection Act of 2019, if you're exempt, you must provide a notice that you're exempt. Okay, this is a form. So if you're renting a single family residence and you want to raise your rent 12%, you have to send a notice that the tenant is exempt. And landlords who aren't subject to the Tenant Protection Act can raise their rents as much as the market will bear. But again, you have to provide them with a notice of exemption. And we have one question here. You speak of the Biden tax plan. I've not yet heard of any Biden tax increase, nor do I think a tax increase would pass the Senate. So a federal tax increase is quite hypothetical at this time. Yes, it is. Biden has released his Green Book, which has proposed income tax increases. Whether those happen or not, I don't know. There are proposals. It just remains to be seen. So when you're dealing with an exempt property, okay, exempt single family residence condo, you should still double check the local city laws. Some have rent control laws that predate AB 1482, and some have special restrictions. So again, kind of a murky area law. I just want to tee this up. It is, it's something where you should seek out professional advice with your real estate professional, quite frankly, or a real estate attorney who's a landlord tenant attorney. Our firm is not a landlord tenant attorney. I don't pretend to be, but I'm going through this within the context of intergenerational wealth creation and transfer, and just giving you guys a heads up that there has been a change in the law. So it's important to understand on a very high level that certain properties are exempt from the Tenant Protection Act, single family residence condo. Multifamily is affected by the Tenant Protection Act. Okay, so multifamily is a non-owner occupied duplex, triplex, fourplex, and up. So there's a three-part analysis. So here you are, you're a landlord. You say, you know what? I watched Jim's webinar. It's time to raise our rents, and I'm going to send out a letter to the tenants notifying them that their rents are going up. So one thing you have to be very mindful of is the location of the property. So first threshold question is the property in one of these cities: Berkeley, Beverly Hills, East Palo Alto, Hayward, Los Angeles, Los Gatos, Oakland, Palm Springs, San Francisco, San Jose, Santa Monica, or West Hollywood? They have their own ordinances. Okay, this is very important. So this gets hyper local really fast. You can't just randomly raise rent on your rental in Beverly Hills. Not going to happen. There's rent control in Beverly Hills. Okay, I know that because my wife and I rented a place in Beverly Hills not too long ago, and we would get a letter from the city asking us, what is the rent that you're paying? So not only do they, not only am I paying the rent, but I'm also reporting that to the city as well. So there's some things that are happening in the background. If you're a property owner, you may not get that letter that comes to the tenant, but the tenant will certainly disclose to the city what their rents are. So Anonymous asks, so if a landlord has not provided the exemption notice and still increases the rent 10%, what would happen to such a landlord? Again, I'm not a landlord. I'm not an attorney who specializes in this area. My guess would be that you would be limited, if I had to take a guess, to the 5% plus the CPI. So that might be an unlawful increase in rent. Now, if it's an unlawful increase in rent, and then you seek to evict the person, that could potentially be a wrongful eviction, thus opening you up to liability that we'll talk about in a few minutes. So this is really important to pay attention. That's a great question, Anonymous. What happens if I don't send them the exemption notice? This is where you need, if you own residential rentals, you really do need to check in with your professionals. And that is probably the single biggest takeaway of this webinar is don't wing it. Don't try and do this on your own. It's your property. It's a free country. And half of Californians are tenants, and they have political capital that they are using to change the rules. So it's very important to understand. The cowboy attitude is fun, but it can get you into trouble. And I say the cowboy attitude lovingly, like, well, I'm going to flaunt the rules, right? So first one, is the property in one of the following communities? Second, is the property exempt? Is it a single family condo or owner occupied? And if it's no to 1 and 2, so if it's not in one of these cities and it's not an exempt property, so let's say it's a multifamily in Folsom, you are covered by the Tenant Protection Act. Okay, so you are covered by this form of rent control. Okay, so it's very important to understand. So what is the maximum lawful increase? Okay, if you can raise it 5% plus the CPI, what does that mean? Well, the CPI, there are a whole lot of different CPIs, folks. There's not one. And which index are you supposed to use? So if you have rentals in different areas in California, do you use the same index? Well, for Social Security, they use the Consumer Price Index for urban wage earners and clerical workers, CPIW. That's to get your Social Security increase. California doesn't use this one. They use a different one. In fact, they use a lot. The CPI is for the region where the property is located. And so if you go online and you look, you will see that there are different CPIs for different regions. So the translation is, it's not one consumer price index, it's the Consumer Price Index for Los Angeles. It's a Consumer Price Index for San Diego. It's a Consumer Price Index for San Francisco. So it depends. You have to use the April CPI, the previous April CPI. You can't just use any CPI, but you use April to April. Okay, so you can see as you kind of go through this, if you're off 0.2% in the sense that you're overcharging rent and you evict someone for not paying that extra 45 cents in rent, you could subject yourself to a wrongful eviction. So you see where I'm going with this. You need to pay attention to the rules, and you need to understand that these are not simple rules. This is a very complex process. And I will tell you, when they say that lawyers are sharks, that is 100% true. Okay. This is like blood in the water for lawyers. So if you're a landlord, in California, please pay attention to this. So here's a lawful raise in rent. Let's say we're renting a place. I put $1,000 in Long Beach just because make the numbers easier. You have a place that rents for $1,000 a month in Long Beach. You want to increase the rents on that property. What is the lawful maximum that you can increase it to? Well, you can increase it by 5%. So that rent could go from 1,000 to 1,050. But you can also add the CPI, the April to April, April 20 to April 21 CPI, which is another 3.6%. So you could lawfully raise the rents to $1,086. I would just best practices, if you're having to use the April index, we're in July, the April index just came out. So it typically comes out in June. So if you're going to schedule these rent raises, you may want to think about talking to a tenant and saying, listen, tenant, every year your rent is going to go up, and it's going to go up in June or July or August or whatever month you pick. But let the tenant know ahead of time, right? And it's going to go up 3% or whatever the number is. I don't, you figure it out. But let the tenant know ahead of time so that they can plan. And instead of not raising the rent, not raising the rent, not raising the rent as the years go by, and you say, well, these are really good tenants. And then you say, wow, I'm so far behind on the rents. I have to raise it 20% back to market value. You're not going to be able to do that. So it's really important to really rethink. If you're not raising the rents annually, make sure you think about raising them annually, and then also do it in a way that's fair for the tenant. That's not a surprise. Okay. Let's say here's another lawful raise in rent. You have a 3.3-bedroom, 2-bath in Pacific Heights that rents for $1,000, and you can lawfully raise this rent only by 60% of the regional CPI. Okay, so you don't get the 5% in San Francisco. You get the 0.6% or the 60% of the CPI. So whatever the CPI is here of 3.8 times 0.6. You can only lawfully raise the rents $22.80, whereas in Long Beach, you could raise it by $80. And this assumes that you're following all the other rules. This is just the rent raise, but San Francisco it has its own cap on rents. Can you exceed the guidance when tenants depart and a new tenant moves in? Yes, that's a law from 1995 that says that these are not hard rent control, meaning you don't have to keep it low. Once a tenant leaves, you can raise the rent. That is correct. And so we have another question here. So Nancy asks, so if I want to raise the rent, hello, Prop 19, right? Because if you inherit a property from your parents now, you're not going to get that parent to child reassessment exclusion. And what happens if your property taxes go so high, there's not enough net income to pay the property tax, and you need to raise the taxes. Okay, so if you need to raise the rents rather. So what if I want to raise the rent, hello, Prop 19, do I need to let the lease run out and get a new tenant, even if the current tenant agrees to raise the rent? Nancy, I think if the tenant agrees, it is probably still an unlawful rent increase. The answer to that question is I don't know, but I will tell you, consenting adults in the state of California can do many things. Okay. One thing they absolutely cannot do is work through lunch, and they need their 2 10-minute breaks. And I would suspect, if I had to venture a guess, and this is just a guess, that you cannot contract around this. But again, I don't know that's something that's out of my zone, but is certainly within the purview of probably a real estate professional who handles rentals in that particular market. That's very important. Okay. So being nice does not pay. Even if you just raise your rents based on the CPI, assuming you're in an area that can do that. Now, certainly if you have rentals in San Francisco, absolutely raise the rents 0.6 times the CPI. You need to do that just to keep up the maintenance on the building, because it's not fair to the tenants. If you don't have enough income from the building to maintain it, then you got a whole host of other problems. And if you go a few years with no increase, there's no aggregation, right? You can't say, well, I didn't raise it for 5 years, so I can aggregate those 5 years. And again, big jumps in rent can be difficult on tenants. A lot of these people, some people make a lot of money, but many tenants, they're kind of living paycheck to paycheck. So it would be nice if they could know in advance that their rent was going up a little bit. And also, if your tenants expect an annual rent increase every summer, they can plan accordingly, as we said. So so we covered lawful rent increase. let's talk about avoiding a wrongful eviction. So this is one thing you do not want to do, okay? In some locations, if the tenant is paying, you cannot evict the tenant, meaning in many locations in California, in many locations, you cannot evict the tenant without cause. There has to be a reason to evict the tenant. Eileen asks, how do you charge a tenant who moves out before the term expired? Should I file the small claims court to collect unpaid rent? If the new tenant moves in and takes the rest of the term, the landlord can still charge the prior tenant for breaking the lease agreement. Yeah, I would talk to your real estate, an unlawful detainer attorney about that. So unlawful detainer is what you're talking about. Although in that case, if they leave and they don't pay the rent, they're no longer holding on to the property. So it might be something else, but that is certainly actionable. Okay. What I mean by actionable is it's certainly something where if somebody agrees to pay rent for a year and they leave after 6 months, certainly you can sue them to recover that lost rent. But on the other hand, you have to mitigate your damages. So there's a general concept in the law that if there are damages, you have a duty to mitigate those. So you can't just sit around for 6 months, not having the property be occupied, but to have that property, do your best efforts to rent the property out. That being said, always check with your local, always check with a local real estate professional or attorney who understands the local rules, because there very well could be a rule that says if you're not paying and you have a 1-year lease and you can't evict me, who knows, right? Who knows what kind of world we're living in? But I would definitely pay attention to the local rules on that. Anita says on the no eviction issue, you mean during the COVID time, for example, or to September 30th? Correct me. So what I'm saying, in some locations, San Francisco is one of them. If the tenant is paying rent, you cannot evict the tenant. Okay, you can't say, I don't like you, I want you out, I'm going to put in a new tenant. But if you do evict the tenant may be entitled to compensation. So this is very important. There is something called the Ellis Act in 1985. If you have a rent control property, this was passed in response to Nash versus Santa Monica. Nash versus Santa Monica said that cities could force landlords to rent properties, that they could not reoccupy the property as their own property. Well, that doesn't make sense. And so the legislature says, well, of course they can. So in 1985, they passed a law that says landlords can go out of the business of rentals and move into the property. Okay. Costa-Hawkins limits city rent control. And this is very important. It limits the rent control that can be imposed by cities. They cannot impose it on newer construction, single family residence and condo by state statute. It also bars vacancy control. So this goes back to the question, if somebody moves out, can I relet the property at market rates? In California, you can relet the property at market rates once the tenancy of the tenant ends. Okay, tenant is the person who holds the property. It's from the Latin tenere, I believe, to hold. So it's the holder of the property. So Vincent asks, can increase to rent set forth in a lease for holding property over be more than 5% plus CPI? Oh, a holdover. Vince, I don't know that question. I see holdovers a lot on commercial leases. I typically don't see them on a residential lease. I would suspect that a holdover would be deemed rent and you would be limited. So how does this work? How does a San Francisco eviction work? And I'll just pick on San Francisco here. Let's say there's a 3-bedroom, 2-bath unit that rents for $1,000 a month in Upper Pacific Heights. That's the view. The people moved in 100 years ago or a long time ago when things were cheap. This property should be renting for $12,000 a month. So the owner can get out of the rental business and move in, right? The owner can say, you know what? I want to move in here because I want to wake up and see the Golden Gate Bridge every day. You can go out of the rental business and you can move into the property, but you have to pay. Okay. San Francisco requires compensation that's tied to the consumer price index. And this actually should be for 2021. It's $7,400 per tenant, capped at $22,000 per unit, plus an additional $4,946 per disabled tenant or tenant over 62.5. So these are essentially relocation expenses, compensation for losing a rent controlled property. Well, Those are San Francisco's rules. Other cities have other rules. Santa Monica requires an owner to get a reoccupation permit. Okay. Remember there was Nash versus City of Santa Monica. Santa Monica requires if you convert your property to your own use and then you're like, well, I don't think I want to live here anymore. I don't think I want the tenant to live here anymore. I want to reoccupy the property. You have to get a permit. Okay. In order to reoccupy your property. They make it difficult. And LA applies rent control provisions to units built on the same property up to 5 years later. So if you kick everyone out, you knock down the building and you build a new structure, you got rent control for 5 years. So pay attention to where the properties are and pay attention to the ever shifting laws. I will tell you, we have all seen it. The post-COVID world is a different world that we're living in, and political power is shifting. And I would say that political power is, there's a lot of political power in the hands of tenants, a lot of tenants' rights. So a wrongful eviction occurs when a rent-controlled tenant vacates pursuant to an illegal eviction notice. So in the jurisdictions where people have a right to live there and they have a right not to be evicted unless it's for cause, if there is no cause and you notify them that you're terminating their tenancy, that can constitute a wrongful eviction. The landlord fails to timely move in after the owner move-in eviction. So you say, get out of that place in Pacific Heights, and the owner or a relative fails to timely move in. You got to move in, and you can't pretend to move in. You got to move in. The rent-controlled tenant is forced to vacate because of a major repair issue. Mold, not covered by insurance. Okay, that's a big one we see. Sewage leaks, rodents, no heat, or a flood. Mold seems to be the biggest ones. And sometimes you will see a retaliatory, when someone's being evicted, they'll counter and they'll say, well, I'm not paying rent because there was mold. And, you know, and then we just kind of go down that rabbit hole. Kenneth asks, for a multi-unit property subject to AB 1482 without local rent control, when can I raise the rent? Do I have to wait until after September 30th? Kenneth, I'm not sure when you can raise the rent, but you have to use the April to April CPI. So if you want to raise the rent in March, probably wouldn't make sense because you would have to be going off the 2 years prior April to 1 year prior April. You got to wait till that April number is released. And so that was the driver. There could be, by the way, you have to check the local restriction. There could be a restriction on when you can increase the rent. It might only be a certain period of the year. I don't know. But typically, if you're going to raise the rent, you have to use that April 1st to April 1st CPI index. So it just makes logical sense to wait until the most recent April index comes out. Unless we have deflation, then you would want to raise the rent in March. You know, I don't know, however you want to do it. The landlord or relative fails to timely move in. Rent-controlled tenant is forced to vacate because of mold. So they stop paying their rent. They say, I'm not paying rent because there's mold. And you say, baloney, I'm evicting you. Now you potentially have a wrongful eviction case on your hands. You know, most unlawful detainers people don't respond to, but this is what I hear from unlawful detainer attorneys, but you got to tread carefully, okay? A landlord fails to offer the rent controlled apartment back following a fire, earthquake, capital improvement, or flood. So yeah, earthquakes happen. The tenant moves out, it's red tagged. It takes 6 months to repair it. And the tenant says, yeah, I want to move back into my rent controlled apartment. You got to pay attention to that, okay? A rent controlled tenant vacates because of a landlord or neighbor harassment, which is kind of funny because neighbor harassment, I know my own son went through that living in LA. They had a crazy neighbor, but you know, sometimes there's not a lot you can do about that. But if there is harassment, you know, that is potentially a wrongful eviction, okay? That's even if a neighbor's harassing them. So landlord who relets a rent-controlled unit to a new tenant following an Ellis Act eviction. And what that means is you kick out a tenant, a rent-controlled tenant saying, yeah, I'm going to move in there. And then, you know, after the tenant leaves, you say you're the landlord, you go, well, I changed my mind. I'm just going to re-rent this to another tenant. No, that's a wrongful eviction, okay? You can't put another person in there. You have to follow the rules, okay? The rent-controlled tenant is forced to vacate because a landlord has shut off utilities or locked a tenant out. I mean, come on, don't be a slumlord. Landlord repeatedly tells a tenant to vacate a rent-controlled unit. Not a good idea. A landlord has failed to deal with a nuisance neighbor for a remote controlled tenant. If you attempt to demolish a rent controlled unit without a permit, that is a wrongful eviction. Okay. And demolishing is that a repair? What is it? We're getting to kind of down a slippery slope. I'm just going through this laundry list so that you understand that if you're doing a repair to a property, you need to address, if you're in a rent controlled property, you need to address the fact that this rent controlled person has rights. You may need to put them up in a hotel, whatever it is. I have no idea, but it's something to think about. So this is why you would want to engage with likely a professional property manager, knowledgeable in your particular locale. Again, this is to protect you guys. Landlord fails to offer a lifetime lease following a condo conversion. You would see that in San Francisco primarily, and LA, maybe West Hollywood. The landlord claims to be living in the unit, but really isn't. Claims to be living in the unit. So we have a story. We've got Andrew who's going to be joining us, and we do have a question while Andrew's hopping on. And need to ask Jim, if the landlord evicts to move in and then a life change occurs and landlord does not move in, do you know if there's a time frame that you must move in? It's going to depend on each locality. But I will tell you, this is something where you just don't do this off the cuff, ad hoc, willy-nilly. You want to really have a lot of mindfulness on this. So Andrew, thanks for joining us. Andrew happens to be good friends of our producer engineer who's handling all of this, who also happens to be my son. So Andrew, Andrew was living in Los Angeles, and he's got a story about from the tenants side. So Andrew, I know you've been listening to this as we've been going through this, and this is really heavily geared toward the, the landlord portion of this. And my general advice is don't be a slumlord and don't be a jerk tenant. Do everything that you need to do, but tell us a little bit of what happened, what your landlord did, and your landlord didn't know that you were friends with everyone else in the complex. Just unpack this. Just tell us the story, Andrew.
The short of it is that I was living in a 2-bedroom bungalow in the Los Feliz, Silver Lake area of Los Angeles. I'd been living there for a couple of years. The property went up for sale and was bought by a new owner. And the owner came in immediately and tried to kind of offer everybody, and these were rent controlled units, by the way. And so the new owner tried to come in immediately and offer us all kind of like buyouts. And we were definitely paying under market value for these units. And so, after doing a little digging about like Ellis Act stuff and things like that, we started to realize like he would have to pay us either, whether he was going to do this ultimately or not. So we decided not to. And then my partner and I at the time, because we were the people who had been in these bungalows the least amount of time, what he ended up doing was serving us with a owner occupancy eviction notice.
Yeah, sort of that Ellis Act eviction, the Ellis Act process we were talking about, where he was saying, Andrew, you and your partner, you need to get out of this 2-bedroom, 1-bath unit without air conditioning, right? And I'm going to move from my big mansion in West Hollywood to, sweat in one of 8 bungalows. And you kind of knew it was baloney.
Yes.
But by the way, those bungalows that you lived at, there's a story behind that. What were those bungalows?
This was the original Disney lot. So it was said that the animators for a lot of the movies in the 1930s and 40s that lived in these bungalows. So there's a lot of charm. Yeah,
and Andrew's in the music industry, so very creative guy. So a lot of creative juju. But so you get kicked out. You're evicted. What happens?
We get bought out. They gave us, kind of like you said, they gave us, I don't know, $8,000 or something like that. And then, like you mentioned earlier, I was close with my neighbors, and and they were not happy about the fact that, this guy was also trying to get them to move out, and ultimately used the Ellis Act to get a lot of them out. And so,
but you guys were friends, right? I mean, you're neighbors. You had each other's cell
yes,
phone. You hung out. You
exactly.
had barbecues, and
I was getting updates, and I was, creating a log of everything he was telling me about what was happening next door.
Yeah. So this is a really important part. And I think this is the most important part. One of the biggest takeaway from the story, folks. Your tenants talk. Okay. If you own a multifamily building, these aren't robots that just, go into their apartment or their bungalow and don't ever interact with each other. These are people that interact with each other, right? I mean, it's just what happens. So, you get evicted, you're talking to the people, then what happens?
Yeah, over time, they're communicating that he doesn't live there. As they're kind of dealing with their own Ellis Act move out situations, one of my neighbors just says, look, I have this lawyer, she wants to talk to you. And I pretty much just got handed a lawyer who, felt like there was enough of a case to do this on contingency. And I said, yeah, why not?
And contingency is, I'm not saying this was not your lawyer, but when you see the billboards, on the freeway, those are contingency lawyers. Those are also known as, I don't want to say ambulance chaser because my dad's a retired personal injury attorney, but these are personal injury attorneys, and they don't get paid unless the client gets a recovery. And you did not recover a small sum, Andrew. I won't ask you how much, but just give us, it
was mid 6 digits.
Yeah, meaning over 6 on the way to 7.
Yeah.
So folks, that is not covered by insurance. This is very serious. What I'm seeing reported, and these are reported cases, not Andrew's case, but reported cases. It is not uncommon to see $200,000, $300,000, $400,000, $500,000 recoveries. Okay. This is pretty straightforward. These are settlements that landlords make with their tenants, and they write their tenants massive checks, not covered by insurance. Okay. So this is really, really important. It was wrong for him to do that. And would you still be staying there, by the way, do you think? Or maybe I shouldn't ask.
I loved that spot. Like I definitely wouldn't have moved. I think I would still have been there probably. Yeah.
Wow.
Yeah.
Well, Andrew, thank you so much for taking time out of your busy schedule. Andrew's a great music producer. So I wish you the best of luck, and thank you for joining us today.
Happy to, Jim.
All right.
Bye.
So I think we can see, folks, that pretty serious stuff. These awards are in the several $100,000 range. Now we do have a couple of clients. So Nancy asked, so if I want to raise the rent, we talked about that one. Venkat asks, if you're going to sell the property, can you evict the tenant, and how much notice do you have to give him or her? My suspicion would be no. Okay. But I would check your local jurisdiction. So San Francisco, no. If you're going to sell the property, you say, well, it's encumbered by all these rent controlled units. Well, yeah, that's how it goes. All right. It just depends on where you're at. So that is locale specific. I would definitely check with your real estate professional. Let's talk about return on equity. There's return of equity, but what we're talking about here is return on equity. For your finance people, you're like, Jim, I know what you're talking about. But for the non-finance people, what it is this is a measure of financial performance. So when you're looking at a real estate portfolio, you really do need to ask yourself on a periodic basis, whether it's annually, whether it's, every 2 years or every 6 months or whatever it is, put it on a spreadsheet, take a look at it, and measure the financial performance. Now, what do I mean by that? Well, you divide your net income by your equity. And we'll have an example on what I mean by that. So you take your income and you divide that by your equity. And because the owner's equity is equal to the property's value minus its debt, ROE is considered the return on net assets. So I'll give you an example here. So if you own Blue Acre worth $1 million with no debt, and your net income, net of maintenance, taxes, insurance, is $25,000 a year, your return on equity is 2.5% per year. That's your return on equity. If, on the other hand, you own Blue Acre worth $1 million and it has $500,000 in debt, and let's say your net income is $15,000, your return on equity is $15,000 divided by the $500,000, or 3%. Now, what you notice is Sometimes it's better to have debt on property. You actually get a higher return. With debt, depending on what the interest rates are. So it's very interest rate sensitive. Anonymous asks, does AB 1482 apply to Section 8 housing? Section 8 housing has its own rules. I don't know the answer to that question. I would suspect that it likely does, but Section 8 has its additional rules on top of those. So some of you who are real estate investors might say, but Jim, it's not just the return on the investment or return on equity, right? It's not like a bond because real property has appreciated. On average, 6.22% over the last 40 years. This takes all the real estate sales over the last 40 years. Depreciation is also a very powerful tax saving strategy, meaning if you buy a residential property and you depreciate it over a 27.5-year period, what does that mean? Well, it says the government, the federal government and the state government, they pretend that 1/27.5 of the property is falling down every year. Just go with me on this. It doesn't even make logic sense, but they basically give you an income tax deduction. So if you buy a property for $370,000, that $375,000 and the land is worth $100,000 and the structures are $275,000, you depreciate $10,000 a year. So that's 1 divided by 27.5 times 275,000 is just the way the math works out, 10,000 a year. You would deduct from your income taxes and pay less state and federal income tax. So depreciation is a very powerful tax strategy for the first 27.5 years. And it's longer on commercial. But sometimes though, the maintenance on fully depreciated properties requires excess capital. What do I mean by this? If you've had a property for 27.5 years, it's going to need a roof. It's going to need a kitchen. It's going to need a driveway. It's going to need all this stuff, right? All this maintenance. And because it's older, right? Because you've had it for 27.5 years. And so what we find is as clients age, they say, you know, owning real estate was really great when I was in my 30s, 40s, 50s. But now I'm in my 70s and it's kind of a pain in the neck. And I'm tired of dealing with difficult tenants. I can't sell 1/20th of my house and use that money to take a vacation or buy a boat, right? If you have cash, you can just take a little bit of cash out of your bank account, right? And it's illiquid real estate. There can be liability associated with real estate. I mean, we saw a wrongful eviction. I mean, can you imagine inadvertently wrongfully evicting somebody and getting tagged for hundreds of thousands of dollars? And again, this is not a pitch to sell all your real estate. I'm just trying to inform you that there are a lot of booby traps out there that you need to be mindful of. Also, there are diminishing tax benefits. What do I mean by that? Well, that depreciation is based on your acquisition value plus improvements, okay? So that 27.5 years, if you've had that property for 30 years, you probably didn't pay a whole lot for the property. So you're not depreciating the full value of the property as it is now, but that snapshot value when you bought it 30 years ago. Needless to say, the cost of upkeep, it's not going down. Also, a neighborhood can change. And this swings both ways. Neighborhoods can get better. Neighborhoods can actually get worse, right? So it's also important to pay attention to the neighborhood's appeal. And sometimes it's time to sell. So Stephanie, I noted this here. I will, let's see. Thank you for reaching out to us. And this is Nick, if you can just write down Stephanie. Anyway, so sometimes it's time to sell. So these are the big issues that landlords face. Selling property. The problem if you sell property, you typically face capital gain, okay? How do we pay property and not pay capital gains tax? How do we not pay capital gains tax at the time we sell the property? And we did a whole webinar on this. Connor and I, he's an associate in my firm. It's on our YouTube page. This is why it's very important. So it's very important to subscribe to our YouTube page because these do come up. I do want to touch on, there was a question here I need to ask, can you speak a little bit on cost segregation in regard to depreciation? Cost segregation is a way of changing the method of depreciation. So typically on residential, it's 27.5 years. Well, if you have a multifamily property of 350 units, a big property, it's a large enough property where it makes sense to consider a cost segregation. Typically, you need about $1 million a basis to really make this economically make sense. So let's assume you have a lot of basis in the property. You can change the method of depreciation. So you can change it from 27.5 years to 7 years for the parking lot, 10 years for the plumbing, 15 years for the roof. You effectively accelerate your depreciation. That is called cost segregation. And that accelerates the tax benefit and reduces your taxes, your taxable income more sooner. So it's more of a reduction sooner on your taxable income. My preference would be, if I can take depreciation over 27.5 year period, I would much rather take that potentially in a 1 year period, right? Because I'm saving the taxes now. I'm not getting that deduction that's worth less. When you look at the time value of money, that deduction over time is worth less, just from an economic analysis. So there's something called the drop and swap in California. Commercial guys and gals are familiar with this. Let's say Abel and Baker buy Greenacre in 1985. And in 1990, Abel and Baker convey Greenacre to AB LLC, right? Abel and Baker LLC. In 2021, Abel and Baker say, you know what? We're going to part our ways and we want to sell Greenacre, but we want to do 1031 exchanges. And we don't want the LLC to do a 1031 exchange. And if you don't know what a 1031 exchange is, we do have a whole webinar on this. We want to distribute this to ourselves so we can each do our own 1031s with our respective halves, okay? With their respective halves of the property. California, this is called the drop and swap. California is attacking this, okay? California will likely treat this as a step transaction. California will likely disallow the 1031. So this is something you really need to pay attention to. Please do not ignore this. Do your due diligence with a savvy real estate professional, lawyers, CPAs. On this one, it's measure 3 or 4 times and cut once. What do I mean by that? You may need to terminate the LLC, distribute the property to Abel and Baker as tenants in common, have a tenancy in common agreement for a period of time, and do it for a reason other than selling the property. Okay. And there are a lot of reasons why people put property in LLCs and take them out. But the step transaction doctrine says if you do a bunch of steps just to minimize taxes, we're going to compress those down into one step and you'll lose the benefit. And that's how California taxes it. So the next one is leaving California, and we will end with leaving California. Many people leave California. Many people come into California. As I mentioned at the beginning, 2 out of 5 Californians were not born in the United States. They're coming from somewhere, okay? But a lot of people do leave California. When people leave California, many times they'll say, you know what? I did my return on equity analysis that I learned on Jim's webinar, and I learned that my return on equity was 2.5% in California, and I could move to Texas and get 5%. So I'm doubling my income and I don't pay state income tax. So I'm going to 1031 my property out of California into Texas. My parents actually did this. They moved to Texas. So they 1031 the property out of California into Texas. And you can move to Texas or not, but you can 1031 your property into Texas. But if you transfer property out of California, you have to continually file every year the Form 3840 with California, okay? You have to report to them, okay? You have to do that and until you die or until the deferral is eliminated, meaning until you sell the property, you then have to pay whatever proportionate share there was of the California capital gains tax, which is really California income tax, because there is no capital gains tax in California. So think about this. You leave California, your property leaves California. California says you have to keep records. You have to keep telling us what's going on with the property. And when you sell the property, you have to pay California their portion of the tax. Now, if you don't file it, they can adjust your income. They adjust it upward. They're not adjusting it downward. They're going to adjust your income and they will apply penalties and interest. So this is very important to pay attention to. So here's an example is Charlie, 1031, I'm using it as a verb. This is Internal Revenue Code section 1031, the tax deferred exchange. Charlie 1031's Blue Acre from San Francisco to Brown Acre in Reno. Charlie moves to Reno. Charlie then moves all his assets to Nevada. So, and Reno's in Nevada. Charlie is a resident of Nevada, of Reno, Nevada, has 1031 his property from San Francisco to Reno, he still has to file a form 3840 until his death, right? Or when the California property taxes are otherwise paid. If he doesn't, he's subject to California penalties. Now, you may think, well, if he's subject to California penalties, how are they going to collect? This is not a framework for tax evasion at all. I'm just telling you, if you leave California, you still have to report this. If you are a retiree of California and the state of California is sending you money, that's a source of money that they can potentially levy, okay? So 85% of California public employees leave California, they retire outside of California. And if you think California is going to give up on this easy, think twice. They're hyper aggressive when it comes to collecting taxes, okay? So let's say Charlie says, I've had enough of Nevada, I'm moving to Tennessee, right? Well, I've had enough of this brown acre property. I'm going to 1031 brown acre from Reno to Red Acre in Tennessee. Charlie stays in Reno, stays in Nevada. He still has to file the form 3840, even on the replacement property. So how do they keep track of this? I don't know. I have no idea. But that brings us to the end of our presentation. And if you would like to make an appointment, there's a request appointment button on our website. I will open it up for questions. Please subscribe to our YouTube page. This is a YouTube channel, rather. This is a really great way to stay up to date. And also, you might invite a friend to attend one of these webinars. This is just a great way. We do these once a week, and I just sort of give you my thoughts on these different topics. And again, I'm not an expert in real estate, but we do have a lot of clients with real estate. And the purpose of today was to heighten awareness, was to raise awareness on all of the potential problems that are out there for many of our clients who are landlords. So I'll open it up for questions. If anyone has any further questions, there's how you can make an appointment. And I will just give it a couple of minutes here if anyone has any questions. Looks like we have. Okay. Well, it looks like it's a wrap. We don't have any questions. I will give it a couple more minutes. But again, you go ahead and subscribe to our YouTube page. And there's also a way to register for additional webinars. We got some great webinars coming up. We will be doing a Green Book webinar here in the near future. It is not scheduled yet, where we're going to unpack Biden's Green Book, which is his proposal for all of his various tax law changes, whether those happen or not. At least we know the direction that at least Biden and the Biden administration want to go. So with that, have a great day, and we will see you soon.